Okay, so this workshop centres around the task of creating a guide for personal representatives. And while we're not in sort of 40 minutes going to be able to create an entire guide, we can at least talk about some of the things, some of the design issues and some of the things that would need to be in and included in that guide. So this is the sort of task I think is very useful to consolidate your knowledge and to think about if you can explain what you know to a layperson, particularly to a layperson who might be in a considerably stressful situation, then you know your material well. So that's the aim of the this evening's workshop. We'll talk a little bit about personal representatives, who are, of course, executors and administrators. And you'll notice that we have another session on that next week, which is our last session. And it's very spread out. This part of the book, there's a small amount of content spread over a lot of chapters. So I cut it from 3 weeks down to 2 weeks. And I must admit, I'm probably regretting not cutting it down to 1 week. But hey, it makes a nice kind of gentle end to the course, rather than trying to pack in intense, action-packed kind of content in the last 2 weeks. Okay. So that's what we'll do. I've created a Google Doc and it's linked into the Moodle shell for this week. And that means that if you click on the link, you'll be able to not only view, but you'll also be able to edit that Google Doc, which, again, I'm not expecting we're going to be creating a masterpiece, but you can sort of type in notes and things as well. I've got my chat window open. So yeah, not the most exciting thriller-minute, academically demanding area of law ever. But I think at this time of the semester, you probably don't want that. You probably want something that's going to ease you into the time towards exams and finishing up. Some questions about the quizzes. It's probably a good time to answer the questions about the quizzes now, because it's sort of, this is the revision point of the evening before we get stuck in. So if you've got questions, please fire away.
Hi, Scott. Sorry, I just wanted to ask, just with the rubric that you've put up on Moodle, one of them refers to discussion of legal issues. I thought our reflection was to do with those reflective questions at the end of the workshop for each week.
Yeah.
Are we supposed to be picking out cases as well to comment on?
No, not unless there's something you see that you think is an interesting connection. When I say legal issues, I see legal issues in the big picture of everything from client interviewing.
Okay.
Yeah, it's the whole shebang. So if you say this, this connects to something else I've studied, and it could be a case, it could be legislation, it could be an article you've read, it might not even be a law subject you've studied. You can draw those connections. That's always good for reflection. It always shows that you're integrating knowledge. But no, I don't expect, particularly for a little 10% piece, to go away and sort of conduct legal research and give me cases and authorities on it.
Okay.
Yeah.
No, that's okay. I was just a bit confused and I didn't want to submit them without checking that first in case I need to fix a few things up.
Yeah, no, that's cool.
Now, the other thing is, how do we go about submitting them? Because it's got a little section on there that says attempt quiz.
Yeah, I think
Are we supposed to select that or?
Yeah. The problem with it was the whole Moodle shell was set up kind of under a design that I didn't want to use. So what I've set it up is kind of like a one short answer question quiz where you can just kind of type the material in there. But what you could also do is you could conceivably, put a link to a Google Doc or something else in there as well. That would probably work. But
we can't submit a Word doc?
Doesn't seem to be able to allow you to do that. And doesn't seem to be fixable either.
Okay.
But given the small number of students, if you really are worried about losing your formatting and everything, just send me the Google Doc as well, the Word doc as well. I wouldn't do it if there was 200 students in the course, but I can do it with 15 or 16. Yeah.
Yeah. Okay. All right. No, that clarifies for me. I just didn't want to press attempt quiz in case it was something completely different and I wasn't ready for it.
Yeah. No, that's fair enough. And this is the first time I've used the CQ version of Moodle anyway. It's been a little bit of a disappointment to me as well in making it work.
Okay. And the cut-off date's the 2nd of Feb for all of those?
Yeah.
Yep. Okay. Now that clarifies everything for me. Thank you.
Great. Cool. I've actually got up to date with marking of those that have been submitted. So there was something weird wrong with the notifications, and there were ones that had fallen through, but I think I've grabbed all of those. So we're fairly confident heading up to the exam, I think. And a little later, I might make a couple of comments about the exam, but I don't have a lot more to add. But I might make a couple of comments about that. Okay, so personal representatives. Was there anything in this week's readings that anyone thought was contentious or difficult or wanted to raise? No. Let me just have a quick squiz as to whether there was anything I underlined at the time and have forgotten that I underlined. One thing I hadn't really thought about was the multiple executors issue, and having executors when you have property in different geographical areas, or having different executors for different property. So there's the potential to actually have a specific executor, like to have one executor who deals with the family stuff and a specific executor who knows more about the business to deal with your business side of your estate. And it's something I hadn't really thought about myself, but it probably makes a great deal of sense, and leaves you in a position where you could have a family member be an executor for just the everyday issues. But if you've got a really complicated corporate situation and a business that you want to make sure keeps running thoroughly while the probate process goes through, having different executors nominated would be a sensible thing to do. So that doesn't fall into a earth-shattering thing, more of I just thought that's quite interesting idea. You can have trustee companies as act as executors, although they have to have an individual person in that capacity. Another thing that I thought was quite interesting that I didn't remember from my studies was that once you've accepted the offer of executor, you can't renounce it. And that seems a little old-fashioned and a little where much of the rest of succession law has really kind of become very warm and fuzzy is not really the right word for it, but it's become very kind of, we can do it and we can fiddle it and we can fix it and we can make sure it all works. The situation where you get the all or nothing on being an executor and at some point get distressed and say, I can't handle it anymore, and get told, no, that's it, you're an executor, you've accepted it. That does seem a little incongruous. I also realise that it would create a lot of difficulties if part way along the way someone did decide to back out and renege on the deal. But it does leave you in a weird situation. I'm not sure, but maybe the only way to stop being an executor is to commit misconduct so that you get removed by the court. Seems to be about the only thing. So I guess maybe if you don't want to be an executor anymore, just don't do anything and wait for someone else to apply to the court to have you removed. And just because it's nice to have some, legal jargon in there, the executor de censeur, who's an executor who's not a real executor, who comes along and acts as an executor, is an interesting concept as well, because the rights of third parties, as against an executor de censeur, are protected to a degree. So that's interesting. If you've got someone who has no authority to come along, they're not protected from what they do, of course. But third parties who in good faith may transfer assets and things under the belief that that person says they're an executor, they seem to be an executor, have protection. So if the bank, as a just vague example, gives the executor de censeur money out of the bank account for the burial or the funeral, believing that, of course it needs to be cleared, and before the estate's cleared, that debt needs to be cleared, they are not then liable for the fact that that person is not actually the executor, provided certain conditions are met. So not sure how often that happens. I'm not sure that there's a league of weird con artists out there pretending to be executors. But possibly there may be even people who are mistaken, who start acting, who believe, of course I'm the executor. They told me I'd be the executor. And then when the will actually is found, because it can take some time to find the will, it's suddenly, well, oh, okay, I'm not the executor anymore. What do I do about that? Okay, so next week, the last of the things we look at is the rights and protections of executors, so that we go into a bit more of that stuff there in terms of when executors make mistakes and how they're covered and to what degree they are protected. And the only other thing I think that was particularly, much of the rest of the material in those chapters that was interesting are things that you've pretty much covered in your assignments anyway. So some of those issues around burial issues and decisions relating to the wishes of the deceased in relation to funerals, and sort of interesting but not crucial issues about disposal of bodies and disposal of body parts and things are in there. So anyway, those are the things that I kind of tagged as things I thought that were interesting. Now what I might do is see if I can find the Google Doc. Make sure I don't have like the exam open or something before I do this. And share the document. It's not working. Get there. There we go. I haven't used Apples for years, and this is sometimes a little bit counterintuitive. Hooray! There we are. Okay, so there's some general headers that I've put in there previously. So let's start with what sort of things do you think should be included? How do I reduce the size of this window? Do that. So if you're in the doc, you should be able to type stuff. Otherwise, you can type stuff in group chat. Otherwise, you can open your voice channel and speak. You've got lots of multimodal options. So what do you think in the top 3 things an executor needs to know? Or if you were an executor, you'd need to know.
I would think they'd need to know the assets and liabilities of the estate.
Yeah. So let's just put nuts and bolts. So they need to know how to find the assets, liabilities, and how to get access to them, what they can do with them. So there's a real why I said nuts and bolts was there's a real practical level.
Yep, I would. Oh, sorry, Scott.
Yeah, go ahead.
I'd also think they'd need to know whether or not there is actually a will.
Yeah. So what can we say? Maybe it'd be basic issues around wills and help with locating wills. So they're not necessarily going to need, and what I'm thinking here is something that might be like a 3-page handout or a fold-out glossy or something that you could give to your clients. That hasn't got everything in there, but it's the sort of stuff they need to know and might have links to other things. So they need kind of a little bit of maybe a checklist for things they need to help if I could type. Checklist of legal issues and factual issues. So yeah, you need to find the will. If you can't find it, here's some of the places it might be. As I think I said last week, in the old days, people always kept a copy at the bank, and that's less frequent these days. And like who to ask, which I guess depends on the family. But if sometimes where there's people who work, for instance, somewhere. I'm thinking if you work somewhere like a solicitor's office and you're looking for that person's will, they might have left a copy with their boss. There might be someone that they trust in a professional sense that they've got it. So there's the finding the will stuff, and then there's all the what you need to find out from the will. What are the important facts? Yep. Okay. What else could we put in as a basic issue?
Yeah. One of the other important facts I was thinking is when they locate the will, if there's any specific wishes as to burial or cremation.
Priorities and urgent, especially funeral, cremation. Yeah. What else? What else might be urgent actually while we're on that topic?
If there's a certain religious.
Yeah.
Yeah.
Thinking also maybe
organ donation.
Oh yeah. Also, I think there might be, I don't know quite the right word to put, but some sort of volatile properties, assets, and responsibilities. So obviously, if you've got a very valuable Persian cat that you're bequeathing to someone's going to have to feed it in the meantime. And similarly, you might have investments or something that need close attention urgently, that it can't really wait for a week till you... sorry.
There could be things like we've just had one at the moment where we've got a conveyance in a deceased estate matter, and one of the parties has actually died.
Yeah, so you've got outstanding contracts.
Yeah.
And I guess this also goes into what we mentioned earlier about liabilities. there are things that that are debts and liabilities too that might be on terms that need to be resolved relatively quickly. And again, at the end of the day, it's probably, people will probably in most cases will make allowance if the person who owes them the debt's actually dead. But it saves a lot of bother of people, the local council issuing final notices on rates and things, to be able to get in early and to say, okay, check these sorts of things need to be dealt with. And even if those debts aren't paid straight away, that the debtors need to be told the person has passed, and we need to resolve those things. Okay. Anything else we need to put in there? Oops. It's looking like a good start to me. Looking much better. We can go back and we can add more things later as we think of them. So structure and formatting. What do you think would be the most useful?
Do you mean, say, in terms of like a flow chart or something?
That's a... definitely put that down as a note. And obviously concise. But also sort of like what are things we need to think about when presenting this information? Should it be something that's online as well? That might be good in case you give a client a handout and say this is something. I've just got a notice saying Messenger is inactive. Can you still hear me?
Yes.
Okay, good. I'm still here. Thanks, Andrew. Okay, so yeah, Andrew suggested that we have clearly divided sections. Your role, things to be aware of, which is a great point. I was looking at a lot of the help sheets and guide sheets from various firms going into preparing for this subject. And I'm still quite amazed at how many law firms, I mean, some of them are great and some of them are doing like YouTube videos and things, which is really interesting. But so many of them will have like a 4-page doc with no subheadings, no headings whatsoever, and just a big long list of cases and things. And I'm thinking, yeah, that's going to be really useful for the distraught and stressed out executor to read. So yeah, I think having things really concise would be a great idea. And then there's, I don't have a strong opinion on this stuff, but there's the whole, one page, 2-sided A4, is that a good format? A gatefold, sort of A4 on its side, folded into 3. Yeah, those sort of things are all valid options to think of. And yeah, increasingly we think about these kind of resources, can we make them as video resources? It's an interesting new world. Once upon a time, we'd always be looking for, we'd say that would be way too expensive to hire a video company and do it, but now people are all doing that stuff on their PCs. Links to other resources and services that we could include.
Funeral directors or things like that to help with burial.
Yeah, depending on, this is probably also going to depend on the size of the town you're living in. If you're living in a small town, you may well be able to say, here are 3 good people to be in contact with. In a big city, it may be your clients may come from such a large area that that's not going to be necessarily feasible. So that's all going to really depend. And also, there's some interesting professional ethical issues, I think, tied into that. To what extent can you, as a lawyer, recommend the services of another professional? And this has popped up, I know, in terms of accountants, because some of the work we have done in community legal centres involve referring community legal centre clients to other professionals and also to other lawyers as well. And it's always a very tricky issue because you can't really say, oh, look, there's a mate of mine who's an accountant. He'll set you up. He'll be good. That's kind of on the wrong side of unprofessional. However, it is also professional to provide good advice when you know there are people who are trustworthy and reliable. So that it might be more in the style as to how you present it. Yep. Other things we could link in there? Court procedures. Might be a good one. And again, depending on the I think actually the public trustees office is probably generally a good thing to connect, especially because they have general guides and information. So yeah, a lot of the state offices of public trustees, while the estate may not be in any kind of peril of having to use the public trustee, because obviously as an executor you've got one, they do tend to have some good advice on estate management and estate planning. Oh yeah, grief counsellors, good point. And again, this is interesting. When I qualified as a lawyer, which is not all that long, it's only 20 years ago. It was not all that long ago in the scheme of the cosmos. We've had very, very strong professional boundaries, and the idea of considering grief counselling and things for clients was definitely in that fits in the box somewhere else, and that's just something you don't deal with. And the most we ever had, and I think I've told you this story about our family law teacher who said, when people start crying, you give them a box of tissues and say, go wait outside because, I'm charging billable hours and you don't want to pay for me to sit here and watch you cry. Which sounds awful, but you also, when you think about that, if you are charging them billable hours, it probably is quite honest. But the world has changed a lot, and law firms, especially the big firms, are really going into interdisciplinary practice. And particularly US firms, you have accountants, you have lawyers. I don't know about psychologists and counsellors, but I wouldn't be surprised, particularly in California, whether you wouldn't have people all under the same roof, and it could all be offered as part of the same service. So, yeah, I think that's something that's worth considering as well. Okay, so we've got some interesting things to think about putting in there. No one said we need to put in the case law and the precedents, which is good. And I think that's right. The things to be aware of is not only a structuring thing. It just occurs to me that it would be an excellent section in itself. And that's where your experience and your experience as in combined experience of all the people in your firm can actually provide some very specialist and contextual advice. What do I mean by that? Again, depending on the size of your practice, the size of your town, where people are located, these things will often be different. If you have a practice that serves a lot of corporate clients with big businesses, their executives are more likely to be professional people, and the advice you're going to be providing them is going to be a lot more formal, and you're going to assume a whole lot more legal and financial expertise, and possibly you'll also expect that there won't be the grief counselling issues, because quite often they'll just be business associates that will be executors. Now, if you've got a small firm in the suburbs or in a small town, and most of your clients are people who have very small estates that are just personal property and so on, again, it's going to be different. We've discussed a little earlier the idea of some of the problems with family provision, the family provision sections and rural properties. And there's definitely a perception that in some ways farms are under attack from family provision claims, and there's often a situation where farms are being broken up by claims. So again, if that's the priority of your practice, if you're in a rural area and there's a lot of farms, you might need to, in your things to be aware of, say, there is a section called family provision. Other relatives may be able to apply for it. This may be a situation where you may want to have mediators involved at an early stage, because obviously, even where people make family provision arrangements and entitlements, it's so much easier if that can be mediated in a way that keeps everyone happy, and keeps as much of the property of the estate together. And I'm just going to, while we're out there, put mediation services down. And again, this is the changing nature of the profession and the way the law operates. Because, you know, the old role of the executor was just to go in there with a big knife and just carve up the property and hand out the pieces of it. And I think these days we're much more open to the idea of saying, well, someone actually is entitled to X amount as a share of the property. However, if they've agreed to actually take it in instalments over a number of years, and we can set up a legal structure that, you know, we're not just going to do that as a shake of hand. We set up a trust or something where rather than split up a property, you know, if the property doesn't have enough cash in it to pay one person out completely, we set up a trust and that person gets paid a certain amount of income under that trust. Again, because there are so many of those sections of the succession law that allow you to, rather than go by the strict letter of the law, to actually go for what the intentions of the testator would have been, I think that gives us a lot more room. Sorry, that was a long roundabout way of getting to that point. But I think we're in a situation where we are much more open to making a solution work rather than making it quick, and making it sort of quick and concise and paying everyone out straight away. I could be wrong, but my perception is that with the rise of alternative dispute resolution, that happens more often. Do you guys have an ADR subject in our course, in our program? Oh, here we go. Yeah, okay, that's good. That was brand new when I was studying. It was a big issue. Was should lawyers be dealing with this kind of mediation and arbitration stuff? But it really is part of your skill set now, I think, and it's definitely worth doing. I actually trained and qualified as a mediator, and while I haven't done it very much, it's certainly helped me as a manager and as an administrator, because it gives you a way of thinking around issues and conflicts that's really useful. Okay, so we've got a point Megan's made back there about infant children. planners, definitely worth having a specific section in there. Lots of complicated stuff. I mean, with children, there's all the guardianship issues that arise. And you've got children who are already traumatised without having to try and move them around too much. But you can also imagine families being what there are. There can be some kind of nasty opportunistic things happening where, where, you know, the people are separated and divorced and everything, where some members of the family immediately latch onto the children who aren't custodians and try and get sort of, I don't know, sort of title by adverse possession, where you know, the old lie about possession being 9/10 the law, but basically put themselves in a situation where they have custody, they have physical custody of the children, and then they make it a point of, if someone else wants to, who is the legit guardians, want to have access to them, they've got to then use the legal system to get them away from them. And yeah, so there's no doubt a whole lot of pointers in there for things that the executor needs to get onto really quickly. And, you know, the kids have been sitting with grandma and grandpa because it's horrible, the sudden things happen. And grandma and grandpa have got the kids at the moment, but the executor needs to step in really firmly and fairly promptly and identify who the correct guardian is and make sure that there's a neat transition of the children to the guardian. So you don't have a situation with, you know, 2 weeks later the kids are saying, we don't want to leave grandma and grandpa, and the legit guardian saying, we don't want to have to go to the court to actually get them away from grandma or grandpa or whoever. Okay, so lots of things to think about there. And while we haven't ended up drafting a whole document per se, I think from my point of view, this exercise is a really good one to step outside of the law books and to actually sort of think about the way you represent your profession, and to also think about, I mean, back in the old days, there was very much that idea that you couldn't give trade secrets away, and that what you did was kind of magic, and that you as a lawyer, people came to you as a lawyer and you said, don't you worry about it, I'll go and do this and I'll fix it up, and then I'll give you something and I can charge you for it. Again, the profession's changed. People, particularly people of the internet generation, want to be able to see what you're doing and understand what you're doing. I suspect that can possibly go too far. I mean, I know doctors complain a lot about people sitting in doctors' surgeries in consultations with their phones out on web GP, saying, you know, I know, no, you can't prescribe me that drug because this says this and it's counter-indicated with this drug and whatever. And it drives doctors crazy, that people are, you know, saying, well, you're seeing me as a doctor, I'm your doctor, I'm professional advice, and yet you're sitting there looking at the internet and disputing everything I tell you. So it probably happens with lawyers as well, I'm sure. But yeah, I think we're seeing a transformation of practice, and we're seeing a situation where more and more we're going to be, in some ways, giving some of our information away on the understanding that when we are really needed, that's when we earn our keep. And if people have a positive attitude to us because we've given them free advice, whether it be, you know, a community legal centre or these sort of resources, then they'll be more likely to come and see you when there's a serious issue. So I mean, that's the thing that, you know, putting advice on how to, you know, and I've seen we've looked at earlier quite a few of those firms, like, you know, small firms' websites have like how to do a will and got advice on doing a will. They don't say, come and see us, don't do a will of your own, whatever you do, because it's too dangerous. They say, no, here are some things about creating a will. But when they say, if you've got a complex one, it's really worth having us do it for you. And I think there's an interesting balance there. Okay, I'm going to stop sharing our little Word doc there. It's going to stay on Word. If you want to refer to it later, hopefully it's been an interesting exercise for you all. Any questions about the process, what we've done. Okay, I'm going to stop recording